Good afternoon, everybody, and welcome to this rapid response webinar on the COVID-19 pandemic from the American Bar Association. This is COVID-19 and the compassionate release of elderly or infirm or in high-risk prisoners, brought to you by the ABA section on Civil Rights, Social Justice, the Standing Committee on Legal Aid Indigent Defendants, and the Criminal Justice section. I'd like to introduce Judy Martinez, who is the president of the American Bar Association.
Thanks, Malia, and thanks to all of you for joining in on this webinar today on this very important subject, the compassionate release of the elderly, infirm, and high risk who are incarcerated. Today's program focuses on efforts to secure the release of those who either by age or health condition are necessitated to try to help them stay safe from the high impact risk of having a serious case if they contract COVID-19. And the ABA criminal justice standards on the treatment of prisoners state, when public safety and the interest of justice would not be compromised, governmental authorities should provide judicial and administrative mechanisms to accomplish the early release of prisoners in exceptional circumstances. The pandemic that we're facing now is truly, without doubt, an exceptional circumstance. We are grateful for you, for the concern that you are evidencing by participating in this webinar and the work, more importantly, that so many of you, including our panelists today, are doing to pursue release and make our correctional institutions less dangerous places. During this crisis, the ABA is working hard on numerous fronts to effectuate this policy and many others. Through webinars like this and other methods of sharing materials and lessons learned across bar associations and across communities, and also through our governmental affairs office advocating on many fronts for consideration here of prisoners who are facing COVID-19. And it's important to understand that we advocate at significantly different levels and ways, and we certainly reach out and make sure that we're advocating in a way that will reach speedy results and the best results possible for those whom we're all committed to serve. We also have created an ABA task force on the legal needs arising out of the 2020 pandemic. We're delighted that Jim Sandman, the immediately past president and president emeritus of the Legal Services Corporation, stepped up once again to serve and chair that task force. And importantly, that task force has so many critical partners and stakeholders at the table, including the Conference of Chief Justices, the Administrative Office of the Courts, the Court Administrators Association, COSCA, the National Center for State Courts, NLADA, the National District Attorneys Association, and many ABA entities, sections, divisions, and forms, and commissions, and standing committees, and special committees, and many more. So we are glad that you could join today to be a part of this webinar. I want to thank our extraordinarily talented and experienced and dedicated participants who are serving as panelists. We urge you, if you're not a member of the American Bar Association, to join our community. For those who already are and understand the value of the ABA, we thank you for your membership, and we thank you for your committed and dedicated participation in the ABA. With that, I'll turn it over to Malia Brink, who serves as counsel for public defense for SCLAE, the Standing Committee on Legal Aid and Indigent Defense of the American Bar Association. Thank you and good afternoon.
Thank you so much, Judy. I just want to do a little bit of a technical introduction before turning it over to the substance of our program. During today's program, we're going to encourage you to ask questions of our panelists. To do that, we'd like you to use the question and answer function, which is a window that you should be able to open if you just cursor down below the people that you see. The Q&A box should be there. You can pop it open. If you ask questions in the Q&A box, I'll be able to answer them during the course of the program, or shoot them over to the panelists or to our moderator rather, so that she can ask them of the panelists. For purposes of this webinar, that is the only way to ask questions, is through the Q&A box. We'll be sharing a recording of this webinar with everyone who's registered, and you should feel free to share it widely within your networks. As Judy said, this is free and available to the public as a public service during this pandemic. We will also continue to add materials related to compassionate release to that site. Please feel free to leave us feedback, ask questions, recommend materials. We are thrilled to have you here today. And with that, I'm going to turn it over to our moderator, Miriam Gohara, who is a clinical associate professor at Yale Law School and also serves as special advisor on public defense issues to the ABA Standing Committee on Legal Aid and Indigent Defense. Miriam?
Thank you so much, Malia. And I really want to thank you, Ali and Judy, for the ABA's leadership. Really, these webinars have been an invaluable resource, and I know when I share them with my colleagues, they're very grateful. So we appreciate all the organizing you're doing. So as ABA President Judy Perry Martinez said at the opening, the potential risk for the spread of COVID-19 in jails and prisons has brought serious attention to our levels of incarceration and to the conditions in our jails and prisons. The CDC has issued guidance for correctional institutions to engage in enhanced cleansing and disinfecting, as well as to implement social distancing strategies. But of course, in many, many institutions, these guidelines are impossible to follow. So without significant reductions in the incarcerated population, people who both live and work in prisons and jails are at great risk of contracting this virus. As we look at how to reduce the populations in prisons and jails and to curtail the spread of COVID-19, special attention should be given to prisoners who have special health conditions or who are older and who are most vulnerable to severe cases. While almost every state has judicial or administrative remedies for releasing such prisoners early, release under those programs is rarely used and rarely achieved. So our panelists today, who I'm thrilled to meet, are all working through different means, litigation, legislative and administrative work, and advocacy to secure the release of high-risk individuals in response to the COVID-19 pandemic. So our panelists today are Margaret Egan, who's the Executive Director of the New York Board of Corrections. The NYBOC is a civilian oversight board, which has called for the New York City jails to take immediate steps to combat the spread of COVID-19, including the release of certain high-risk prisoners. Murph Eamon is Executive Legal Director of Columbia Legal Services. Columbia Legal Services has filed a petition pending before the Washington State Supreme Court and set to be argued on an expedited basis that seeks the release of older prisoners and prisoners with serious health conditions. Mary Price is the General Counsel of FAM, Families Against Mandatory Minimums. FAM has long advocated for the use of compassionate release mechanisms and has a report and website devoted to how those mechanisms work in each state. FAM is also organizing volunteer effort to seek release of at-risk prisoners due to COVID-19. And Mary will talk about the various mechanisms that can be pursued to secure release. And we'll also talk about the federal response and what she thinks will happen as a result of steps taken recently by U.S. Attorney General William Barr. I'm gonna begin with a series of introductory questions that I'm hoping each panelist will use to provide us with an overview of their work and their efforts. So Mary, if you don't mind, I'll start with you. You've been working for quite some time to secure the release of older and medically compromised prisoners under various compassionate release mechanisms. What is compassionate release and how does it usually work? Is it something that people usually seek on behalf of individuals? And who usually has the power to grant early release on compassionate grounds?
Thank you. It's an excellent question. And thank you everybody for joining us. And I'm delighted to be on this panel. Compassionate release is a mechanism. It's the colloquial name for the mechanism. Not everybody calls it compassionate release, but it's a series or steps that jurisdictions use to recognize that a person's continued incarceration no longer serves the purposes of punishment. And nearly every state, barring one, Iowa, and the District of Columbia and the federal system have some form of compassionate release mechanisms. But as you point out, Miriam, they are very rarely used. In the state systems, particularly in our research on state systems, we did a report a little over a year ago looking into the Compassionate Release Authority in every single state in the District of Columbia. And while, as I said, most jurisdictions have them, they are very rarely used. And for a variety of reasons, I think. They are cumbersome. They are often loaded down with many, many layers of review, criteria for compassionate release, even for the most vulnerable people, people who are terminally ill, may be unduly strict. or unclear, so that people who are in the clinical process or in the staff process within a Department of Corrections or a parole board may not understand how to use them. There are a ton of barriers to compassionate release, and what happens is at any step of the process, somebody can get halted. And so when we wrote our report about compassionate release, and you can go to our website at fam.org and find every single state's system laid out, we also did a report about what those barriers are and recommendations for overcoming them. How can jurisdictions improve compassionate release? And there was actually in this last legislative session a number of states who had begun the process of sort of looking into this. And of course, that's all, you know, I mean, everybody slowed down or stopped, and we don't know what it would have resulted in, but there were some promising steps. For example, Illinois, Massachusetts made some good changes before. Amazingly, the federal system is the model right now, and that was not the case for many years. I've worked on compassionate release since I joined FAM almost 20 years ago, and my organization is an organization of prisoners and their loved ones, and we were hearing from people trying to get out of prison because they were dying or very ill and unable to access that process. And so changes were made, and I can talk about this later on because I know so much to go over, but changes were made in the First Step Act to the ability of prisoners to access courts, which is in the federal system, it's the sentencing court, court of jurisdiction, that grants compassionate release. But getting to court, it can be very difficult. And what happened in the First Step Act is that prisoners were given an easier avenue to get to federal court and to put before the court their own argument for compassionate release. But it, like the state systems, is unsuited to this emergency. A prisoner has to wait at least 30 days. They can ask a warden for compassionate release, but then they can't even think about filing in federal court for 30 days. And so our efforts right now in the federal system are trying to throw away the book, litigation-wise, to come up with good and creative new arguments so that courts can consider these cases. And some of that work is beginning and bearing fruit. But our effort right now at FAM and with other organizations is to sort of build an army of lawyers who are trained to do compassionate release work, give them all the resources they need, the briefs, the motions, everything that they can use to support them, and then match them up with prisoners that we have heard from. We have access to 40,000 prisoners in the federal system through our court, what's called a core link system, is a phony email system. But anyway, we are gathering the names of people who may be eligible and working to match them with trained lawyers to bring those cases. And I'll stop there because I know there's lots of other things to talk about, but we can talk more about any of those in the question and answer period.
Yes, and I want to make a plug to all participants to look at the link to this webinar, because the resources that are posted there are really quite remarkable, including the report that Mary just referenced, litigation documents from Murph's work, and from another panelist, Michael Bean, who was unable to join us today because I believe he's in court. And so I really encourage you all to look at that website. The ABA has done an amazing job of the resources, and they're incredibly instructive. I've already looked at them and learned quite a bit. Margaret, I'm going to ask you the next question. As part of the civilian oversight entity, you're trying to use persuasive methods to convince political actors to take certain steps to reduce the prison population, including releasing people who are most at risk for severe cases of COVID-19. Can you tell us about your organization, your efforts, and what's happened so far?
Sure. Thank you very much for having me. So the New York City Board of Correction actually was formed in 1957. It's a 9-member body appointed by the mayor of New York City, the city council, and the judiciary. In 1977, the board became an independent organization. At its inception, it was more of an advisory body to the City Department of Corrections, and in 1977 became an independent oversight body. We actually have broad oversight authority under the New York City Charter, and have established in local law minimum standards that govern the operation of the jail. So minimum standards around general conditions of confinement, medical care, mental health care, restrictive housing, punitive segregation, et cetera. And so, you know, the way we are approaching this epidemic is to think about our oversight capacity to monitor the Department of Corrections response to COVID-19, as well as correctional health services. So our oversight extends to the medical provider in the New York City jail system, which is Correctional Health Services, which is part of the Health and Hospital Corporation of New York City. And so we're looking at, how do you monitor the department and CHS's response to COVID, but also how do we monitor the general conditions of confinement in the jail system in the midst of a crisis? And so we've taken sort of a three-pronged approach. One is to advocate for the release of people who are at higher risk of infection, but also think about ways we can reduce the jail population more broadly to address the issues that you raised around social distancing and sanitation, access to care, access to programming, et cetera. And so could a reduced population improve, to the extent possible, improve the conditions of confinement for all? And so we've focused on advocating for release of different groups of people. We're also strongly advocating for DOC and CHS to say more publicly about their response to the epidemic. We think it's really important that the agencies communicate with the people in custody, their families, their attorneys, and the broader public. And that, in fairness to them, that's a challenge. This is a rapidly evolving situation. It's a complicated situation in an already very complicated operation. And so we've been strongly encouraging them to say more. And we have actually started doing some public reporting with data that we've received from DOC and CHS that shows the number of people who have been confirmed, the number of people in custody who are symptomatic but are pending test, and the number of people who have been exposed but are still asymptomatic, as well as staff. I think we also want to make sure that we're thinking about the impact on staff in this situation, because they are vulnerable as well, and they're coming in and out of the jail system, right? They're going back to their communities, they're going back to families, to grocery stores, all of the things, and then going back into the jail facilities, and so that raises concern. And then we're also monitoring, again, just sort of the general operation of the facilities, looking at, we fortunately receive a ton of operational data from the department and from CHS. And so analyzing that data, monitoring complaints that we get from people in custody, from families, from staff, to identify sort of systematic issues. And then just monitoring again, the general function of the jail system. So we're taking that approach. Releasing people is a huge piece of it, but it's not the only oversight that we're providing.
Thank you. And I will note that even though New York's public officials have been quite vocal about reducing the spread generally, they haven't been quite as forthcoming with regard to the measures that they're taking for incarcerated people or people who work in prisons and jails. And I would say the same is true in the state where I live, Connecticut. So that work you're doing is incredibly important to try to push officials to acknowledge the issue and be accountable. Murph, you're up. You're suing to obtain release in Washington state, but your suit was new and instigated for this purpose. Can you tell us a little bit about your claims in the lawsuit and the status of the lawsuit? For example, how did Columbia Legal come to be the ones to bring the litigation? How did you get to the Washington Supreme Court? And as the first state to be a hotspot for COVID, has there been receptivity to negotiating for a settlement for the relief that you're seeking in the litigation, or do you think it's going to have to be litigated through to a decision?
Thank you very much. Glad to be here. Lots of questions. So first, Columbia Legal Services, we're a legal aid organization, and we are the non-LSC funded organization in our state. So we used to be one big organization, and then when funding restrictions came into play, our state made a decision that we still wanted to make sure that people in prison had representation, and also people who are undocumented, and that people who are poor generally were able to have all forms of advocacy, including class action and policy advocacy, which are prohibited if you accept government funds. So we have existed representing people in prison and doing this work for about 30 years. So we have filed numerous class action cases over the years to advocate for the rights of people who are in prison. And we try to do all of our work through a race equity lens and an anti-racist focus. And we try to be driven by the people most impacted by these issues and by the issues of mass incarceration. So our focus is to end mass incarceration. So how did this case come about? We have community advocates and community groups and groups in prison who were terrified, family members, prison groups, at what was happening. As many of you know, if you're in prison, you cannot get hand sanitizer generally because of the content of alcohol in the hand sanitizer. So it's considered a banned substance and contraband, and you can be infracted for having hand sanitizer. Many people in prison do not have access on a regular basis to soap and to water in order to wash their hands regularly. And folks cannot voluntarily, of course, social distance in prison. So these were the issues that were being raised. There were also other advocacy organizations, the ACLU, our protection and advocacy organization in Washington called Disability Rights Washington, that were looking at the jail issues. And some public defenders were also looking at the jail issues, and there seemed to be more receptivity across the country and Washington to release people in jail. I think because there had been so much work around bail and the racial implications of bail, and how people were simply sitting in jail because they were poor when other people who could afford bail were out. So we decided to focus what seemed to be the more difficult issue, which was, and use our resources to advocate for people who were in prison. We contacted the secretary of our Department of Corrections, DOC, and asked for the release of prisons, asked for other types of demands, access to hand sanitizer, access to soap and water, that there stop being arrests for probation violations and other types of minimal violations that people end up back in prison for. And we had a long list of things that we wanted to change in response to COVID. We've had several calls and letters back and forth. At this point, we have not been able to reach any kind of agreement. It looks like DOC may be willing to go through some of its already available channels to release folks. We don't think that that's happening fast enough. So we decided to file a lawsuit, and we thought that it needed to move very quickly. We were concerned that DOC would not take the actions that folks thought were needed, including public health professionals, scientists, and correctional experts immediately. And so we did not want to file in the Superior Court and then risk going to the Court of Appeals and then to the Supreme Court. And so in our state, we have a mechanism called a writ of mandamus or writ of prohibition. So we filed a writ of mandamus in our Supreme Court and asked the court to find that they had original jurisdiction over this action. And we filed, under our court rules, you can ask for a motion for accelerated review. So we filed that motion in addition to our petition, our 70-page petition. And we tried to get that filed as soon as possible. One of the issues in filing this case is that visitation had ceased. Finally, DOC allowed folks free of charge to use video calling and email, but it was very difficult to connect with folks in prison during that time, and for family members to get information about what was happening. And I can't express the level of concern of family members and people in prison are feeling right now as they are powerless to social distance, to wash their hands, and to get hand sanitizer. So imagine the nervousness or the anxiety we feel on the outside, what people and family members of people on the inside are feeling. And so the other issue is that we had an order from our governor, a stay-at-home order, we use a collect call line for prisoners to call in. They can't use a 1-800 number in prison. And every email that's sent and received requires a stamp that also has to get paid for. So we had to, and it's not, those emails are not confidential. So we couldn't write and get to prisoners fast enough, which is our usual method of confidential communication. We had to figure out the ethical issues involved and get a JPay account set up. And we had to figure out how to move our collect call line so it would forward to people's phones at home. And so we're scrambling to get all that infrastructure in place to communicate with people in prison who are wondering and not knowing what's happening. So we spent 2 or 3 days just sitting on the phones in our collect call line, receiving call after call after call, email after email after email, and putting together a large number of depositions so we could paint the picture for the court of what was happening in the prison. What we heard is the kitchen was still happening in the same way. There were not necessarily extra precautions happening. People were still eating close together. They were eating in shifts now, but tables were not being wiped down in the way that it should be after that. We have one of our lead plaintiffs is, I think she's 21 or 22, she's pregnant, and she has 3 people in her cell. And so as they're making room to quarantine people, people are being placed in very crowded situations. And we think that that is unsafe. And folks are very unhappy for that. Those crowded situations as a result of that type of quarantine are also raising the level of stress in prison. And folks are concerned about issues related to violence, issues related to safety. All of those kinds of things are exacerbated that already are happening in prison. So we were able to gather a significant number of declarations. We also reached out and were able to obtain a significant number of declarations from scientists and infectious disease specialists who said you have to get people out of prison. You have to get people out of prison. That is the only way to safely address the coronavirus. We also were able to reach out to the former medical director of our Department of Corrections, and he submitted a declaration basically saying the same thing. And the previous secretary of our Department of Corrections said if he were in charge now, he would release folks. So, but nobody really slept for probably a week trying to get all this information and put together this petition in this case. We are saying that there is a public health emergency and the court needs to order the governor and the secretary to use all mechanisms available to them to release people who are over 50, people with underlying medical conditions, women who are pregnant. So those are the groups, the high risk groups, people over 50 and women who are pregnant whose release we are seeking. And so DOC has not at this point released people. I think they are willing to consider releasing people who may be eligible under their compassionate release program. But as was stated before, that program takes a long time and there's very, very few people in Washington that actually qualify for it. And we do it through an administrative process. We're asking them to use furlough. We're asking them to reconvene the panel that grants clemency and pardons, and getting the clemency and pardon boards to meet immediately to rush through and consider quickly clemency petitions. And for those that have already been approved by the board, for the governor to act on those as soon as possible. Also, they have the power to furlough prisoners, and so furloughing people as soon as possible and as soon as they can. Many folks have family members in the community who are ready and able to have their loved ones at home with them. So that's sort of the biggest overview. I think that answers lots of your questions. Other issues have come up from victim support groups about what it means to release people. I can talk more about that. The court did grant our motion for accelerated review and found original jurisdiction, and we're on a 2-week briefing schedule. And the attorney's writing the brief. I'm on this call because they are frantically trying to get their brief in before the deadline.
Thank you all so much. So I have follow-up questions for each of you, and I want to just make another plug for the website for this webinar because Murph's pleadings are on it. Michael Bean's litigation pleadings are on it. The report that Mary referred to is on it. There are materials from each of our panelists, and they're they will be incredibly useful to those of you who are interested in the nuts and bolts of how to bring these suits. So Murph, I'm going to ask you the first follow-up question and then turn to Mary and Margaret. The first question, a lot of people in the audience are wondering how you settled on your plaintiffs and how you identified who to name in the complaint.
Yes. First of all, on our website, columbialegal.org, are all of the declarations that we filed in the case. So if you want to see them, you can go to our website. There's a significant number, so I didn't think sending them would be helpful, but I can send the link to that page. So yes, it's always difficult in prison litigation cases to find a plaintiff who, one, is willing to step forward because of the risk of retaliation from guards and from guards and other folks in the prison system. It's a very courageous and brave person to do that. And we wanted to get a plaintiff that represented each of the groups that we were asking for their release. People over 50, people with compromised, and people with compromised immune systems. And I forgot to mention, we're also asking for people who are within 18 months of their release date. So that's the first thing we did, is we wanted to have one person in prison who represented each of those groups. And then we talked to prisoner after prisoner after prisoner. I don't know exactly how many, but probably dozens. And then we looked at the facts and we decided to go with folks, one, who did not have a crime that might scare the court or scare the public. And so that is always a difficult decision to do and to think about. And so we looked at and researched what the prison or the press might say about our named plaintiff regarding that crime that they committed. We never reject or refuse to work with anyone based on crime. We don't do that. However, in this situation, we needed to make sure that we were focused on the issues and not focused on past behavior. And so we really needed to put that forward. So that's how we chose our named plaintiffs. Was there a second part to that question?
No, that's great. Thank you so much. Mary, you had mentioned, obviously, that compassionate release is a mechanism that's been available in every jurisdiction for quite some time, and it's not used that often. Can you speak a little bit to whether there have been efforts that you're aware of to use compassionate release more now because of the COVID epidemic, either through the First Step Act or other, state-by-state efforts that you might be aware of through FAM?
Sure. I'm happy to. I'd preface this by saying that since the First Step Act passed in December of 2018, FAM, in conjunction with other organizations, realized that now that individual prisoners had the ability to file a motion for compassionate release in court once they'd exhausted their administrative remedies, once they'd been denied by or neglected or ignored by the Bureau of Prisons, we also realized it was absolutely critical that people be represented, that we knew that pro se petitioners were going to be opposed, obviously, by the government, and they weren't going to be able to do the job that needed to be done. And so what we did was we set up a compassionate release clearinghouse. We reached out to our 40,000 members in prison and we asked them, do you meet the criteria for compassionate release? Do you think you do? And if so, write to us. And we began to hear from many, many people and screen those cases. And at the same time, as we're doing now, we reached out and began to build up a group of lawyers and working both with federal defenders and with private pro bono counsel to represent those individuals. And we've had over a year's experience now under our belts of filing these motions for compassionate release and getting a fair number of victories that we think otherwise we would not see. Both increases in the number of compassionate release over the old system when only the Bureau of Prisons could do that, but also compassionate release on behalf of individuals who otherwise would be refused by the Bureau of Prisons. So everybody we work with already has heard a no or has been ignored by the Bureau of Prisons. And courts have been remarkably responsive. They have accepted these. They don't always grant, but they grant in many more cases where individuals are represented. So in this period, in this kind of litigating with your hair on fire period, sorry, my hair looks like it's on fire right now. When litigating in this period, we realized that we had to take that model and absolutely push it out, right? That if there was any way to put pressure on the political system if there was any way to try and do something for the individuals who are justifiably terrified right now, that we had to sort of build that out. And that is this sort of second phase of the Compassionate Release Clearinghouse, where we're really ramping up and seeking emergency efforts. The federal public defenders and lawyers that FAM had already had with filed cases, lots of judges are now stepping up their grants or the consideration of compassionate release in this period. And remember, we're only into it for a couple of weeks, right, or 3 weeks. But already we're seeing judges who are looking at these arguments, looking at people who may or may not fit the traditional compassionate release criteria in the federal system, but on whom are the briefs are layering now this, plus COVID-19 vulnerability arguments, and courts are definitely responding to those. So the two barriers to compassionate release in the federal system in this emergency period are, number one, the rigidity of the federal criteria. So you have to be terminally ill or debilitated, or you have to have served a certain amount of time and be a certain age and have a certain kind of medical condition. Those are not easily transferable in this moment. And so what we're doing is we're asking people both to be creative in their briefing, right, to add the COVID vulnerability arguments. But the other big barrier to compassionate release is the procedural barriers, that prisoners have to apply for compassionate release of the warden, wait 30 days, maybe they get denied, and if they get denied, they have to go through this ludicrous, futile exhaustion process of, appealing the denial at various levels. So we're also trying to push that door open as well, to ask the courts to excuse exhaustion or traditional exhaustion because it's either futile or because of the emergency situation. So this is all sort of being developed right now. There have been some victories already in these fronts, and we're trying to take those and push them out the door. We don't know if this is going to work, right? This could be a futile effort. But one of the things I do want to say, and I always think it's important for the work that we're all doing, is that hopefully this puts pressure on the political process, right? That this is an emergency and nobody is prepared to ask for it. I mean, Murph's talking about challenges that, creative challenges that may or may not work. We hope that in the future, what this means is that these mechanisms that we all are trying to use to rescue people, which is what we're really trying to do, are improved, that our political process will look back and say, we really failed prisoners in this system. I mean, we cannot leave people behind like this. This is what we need to do to fix this. So I want us, obviously to be doing the work that we're doing right now, but then to take everything we learn and make sure that as a policy matter that we improve this system. It was already bad and broken before, and now, the fact that too many people are incarcerated, that we have this mass incarceration system feeds this, but also that we just have no way to go back and take meaningful second looks on an expedited basis when there's an emergency like this.
That's actually a great segue to my question for Margaret, which is, on a policy level, so you obviously are doing oversight and, putting pressure on the political actors in that way. And one question is, what are you learning about what the conditions are in the New York City facilities? And also what actions are you all taking or recommending to stem the spread of the virus in those facilities? You're still on mute, Margaret.
Yeah, it just told me that. Thank you. So the condition, so let me back up to say that the conditions in the jail facilities on Rikers Island and the couple of borough-based facilities that are still open weren't great to begin with, right? There has been a push in New York City, a concentrated push in New York City, particularly over the last 3 or 4 years, to close the jail facilities on Rikers Island and build new, more therapeutic focused borough-based facilities. So one in each of the 4 boroughs. Staten Island would not have a jail, but so that work has been ongoing. And so it actually has been a concentrated effort to drive down the population before this came up. So, so the advocacy work that we're doing around further population decline is sort of building on that. The New York City jail population is around 4,500, which is very low for the New York City system. And so the condition, so that should allow for more social distancing, right? You have a ton of space. You have staffing, you have very high staffing ratios. We are, of course, seeing staff getting sick, and we worry about that, but you still have high staffing ratios. And so the department has the ability to increase the amount of space that they're using for social distancing. They actually recently reopened one of the facilities they had closed. But inherently in a jail, I mean, the physical plant doesn't lend itself to social distancing. You still have dorm scenarios where people, so DOC is working on having people have empty beds between them in dorms and sleeping head to toe and trying to create distance. And so we're monitoring to see if that is actually happening. And there are definitely places where it's not happening as we would like it to see it, but they're definitely making a concerted effort. We're worried about the sanitation protocol. So they are doing everything they can to clean as much as possible. But again, these facilities are already run down. So you're trying to create a level of sanitation. And Murph was talking about all of the issues that they're seeing in Seattle. We're seeing the same things. Need for soap, need for cleaning supplies, need for all of the things that everyone on the planet is looking for. And so it makes that a challenge in a jail facility. You have communal showers, you have communal toilets, you have communal phones, trying to make sure that phones are cleaned on a sort of hyper regular basis, because that is a link to families. New York City and New York State suspended contact visits. New York City is one of the relatively few jail systems in the country that still allows for contact visitation. That was suspended a few weeks ago. They have moved to using, giving people more opportunities to use the phones, but that is a way, you can transmit this illness. They are also implementing a video visitation program. So they're using, this kind of Zoom technology or something like it in order to provide access to families. And so what we're trying to do is, to the extent we are updated, and again, we're advocating for constant updates on their response plan, monitoring both sort of in both qualitative and quantitative ways, adherence to those policies and raising issues where we see them. I mean, my goal is to raise problems as we see them so that the department can fix them. I want our oversight to provide the public and families and people in custody with the information that they need and deserve, but also do it in a way that is a value add to the Department of Corrections and Correctional Health, so that they can improve as they go, so that we can build on this evolution. And do this a little bit better each and every moment of each and every day.
Thank you so much. One question that occurs to me to ask all of you is just how obvious it seems to release people who are elderly or infirm, who are unlikely to pose any risk to public safety, who certainly deserved consideration even before this pandemic struck, but are now, especially vulnerable to what could essentially end up being a death sentence if they're not released. And yet it feels like even again in jurisdictions like Washington, like New York, like Connecticut, where leadership has been strong on stemming the spread of the disease in other domains, it has been lacking in the domain of incarcerated populations and people who work in the prisons. And so what advice or wisdom do any or all of you have about how we might really provoke and jumpstart attention to this issue specifically on behalf of the elderly or infirm?
I mean, I will, I guess I'll make an attempt. So we have been advocating far and wide and trying to push on every lever that we have. So, the mayor has some ability to release people who are held on city sentences, and has a work release option. And they have been, to their credit, they have been using that, and we've started to see a bunch of releases of people who are city sentenced. There have been legal aid. The Legal Aid Society has done a bunch of great work to get the release of I think it's now over 100 people on writs. The city has been bringing cases back to judges for on motions to reconsider bail, so that people are released on their own recognizance. We've also been pressing the state to release people held on technical parole violations. I think, there's a doctor with the Correctional Health Services, Dr. Rachel Bedard, who oversees the compassionate release process, the sort of in normal times, the compassionate release process. And she and a small team try to identify cases and bring those cases before judges to secure release. And I think we are going to continue to advocate for as many people to be released in this moment in time as we can. But and I think Mary was raising this point as well. It strikes me that structure, that sort of that process for compassionate release is woefully inadequate in this time and in any other time. I think that given research around criminogenic risk and also health outcomes and all of the things that we care about as a society, does it make a whole lot of sense to be incarcerating people over the age of 50 that are at high risk for this infection or any other? I think it's a moment to ask those hard questions.
I think the response that we've heard and we've been hearing from Department of Corrections folks is that we have everything we need in place to prevent people from getting sick, and we don't need to release anyone in order to keep people safe. And so that's what we've been hearing. I think that's changed slightly in the last few weeks as folks have tested, some staff workers have tested positive and those kinds of things, but that's the message from our Department of Corrections, that people are safe. We're doing everything we can. We have an infectious disease protocol, and we are giving people what they need to stay safe, and everything is under control. So that's why it's really difficult to get people released, because our Department of Corrections, and I think those across the country, think that what they're doing is enough. And so we've been trying through expert folks in their declarations to say that is not enough. This is different. COVID-19 is different than any other respiratory infection like tuberculosis that you've experienced, and what you're doing is not enough. So that's the core of the fight, is the question that you just asked.
Thank you. That actually dovetails a little bit. If any of you want to tell us a little bit more about how you partner with public health experts, physicians, specifically, I know, again, in the materials, I saw some amazing declarations and documents from physicians and public health experts, but if any of you want to speak specifically to how you've been working with those people with that expertise, and how that's been received by courts, policymakers, judges, that would be great.
I can start. I think that the declarations that we had from the experts, particularly the public health scientists and infectious disease experts, was hugely helpful in the court granting jurisdiction. Having scientists say that release is the option that you need to use right now is hugely supportive. It's just not a bunch of lawyers or advocates or prison abolitionist folks asking for release. It is a different profession who understand these diseases and some have practiced in prison for decades. And we have developed some of those relationships we have, like with Dr. Stern and the former secretary. We have sued them in the past, and so over time have developed in some ways a professional, respectful relationship. And I think public health professionals, their job is to keep the public safe. And so if folks are not released, that is going to put a huge burden on hospitals. And so they're concerned for that. We even had a declaration from our state hospital association saying that in particularly rural areas where prisons are, if COVID-19 increases in there huge problems, it's going to put tremendous stress on the hospital system. And so I think public health officials want to work with us. They see it as keeping the public safe and part of their role and their call to do this work.
Thank you. One question that comes up, of course, and one rejoinder that some correctional officials and judges even might have to the arguments is that, well, if somebody is vulnerable, then why would we let them out right now? Or if someone gets infected, why would we let them out? That's even more dangerous. So what are some of the answers or experiences that you have with this? I know that in New York, where people have been released, apparently they've been releasing some to hospitals, but obviously in many places the hospitals are overburdened. So what is something that advocates can say in response to that set of concerns?
Well, for us, I think the key thing is to get people out before that situation. I mean, once somebody is contagious, it's a problem, and they have to be quarantined for a while, and that's a serious issue. I mean, that's what drives the emergency for us, is that we have to get to people before they're in this situation. I think what Merv was saying about the declarations has been critical, and certainly people are using that in litigation. The other way that we use doctors in the compassionate release work that we do is to help lawyers turn medical records into lawyer talk, right? So understanding what a medical record says, I mean, we they look at these and they just don't know what to do. So we've built a bank of doctors who work with our lawyers, are willing to look at them, talk about end-of-life trajectories and things like that, and try and put it into a way that a lawyer can make a good argument in their case. The other, and you're not getting into this directly, but I think that release planning, and I hope we get to that issue, just what happens if somebody's getting out of prison well before anybody imagined, and how are we going to provide for them? What's happening on the outside to prepare families, to make sure that they have insurance and VA benefits and a place to live, and all of those things for people who don't have to be quarantined or who are not in that very vulnerable position, but nonetheless are going to be released into the community. We don't want to dump them on emergency rooms, and we've seen that happen. So another aspect of the work that we're doing right now is to trying to build up the release planning aspect of our support work, working with social workers and others to do that.
Yeah, I think I would echo that for New York, and I think the concern, as you laid out, Miriam, is that if there is widespread infection, especially with among people in jail who tend to have higher risk health issues, you are going to overwhelm hospitals. If in New York City, you're talking about 4,500 people who are sort of, by virtue of the fact that they're in a jail, makes them higher risk. That's a deluge for a hospital, and so the doctors at Correctional Health Services have been pretty vocal in the media, on Twitter, saying, you need to get as many people out as you can. This is terrifying and going to be a huge problem. And to the Department of Corrections' credit, they agree. I mean, they understand that this is a huge challenge for them as well. And so So, you know, I think the actors are for the most part aligned on this. I think the challenge for us is everyone sort of goes through this process in the way they've always gone through the process. You know, someone identifies a case, they go through a case review. Of course, you want to take public safety into account, but how are we defining public safety? So taking cases to judges and sort of going through this process in an epidemic where the world changes every 24 hours is a serious challenge.
Thank you. I mean, you know, so much of what you've all said speaks to the issue that you brought up before, which is that the system in many respects has been overpopulated and under-resourced well before this pandemic. And so we are talking about a real shortage of reentry services and social safety nets in the best of circumstances, never mind in this circumstance. So in keeping with that, the ABA is actually going to have another webinar specifically on the issue of reentry planning for COVID releases. So that will be upcoming for anyone who's interested in addressing that issue in more depth. You know, I think one thing that would be really helpful for us to know as well is how do we begin to press the issue of how urgent it is to thin these ranks before somebody gets infected, because that will make it easier to rebut this concern that once somebody's infected, they should somehow remain in the close quarters of prisons and jails. So, you know, all the work that you're doing is so incredibly important in this way. Are there ways that we can maybe engage the media? Are there, you know, ways we can elevate the voices of incarcerated people themselves in the way that, for example, I thought it was so powerful that so many of the dire prison conditions in Mississippi and Alabama came to light from the words and recordings of incarcerated people themselves, or certainly their family members. You know, how can we sound the alarm on this before there's a really serious outbreak in a prison or jail, and you know, maybe encourage more people to take the lead that Kentucky's governor, for example, took just yesterday in releasing 900 people under categorical release, and then another 743 on the basis of infirmity or vulnerability. What do you think are some things that advocates can do to elevate this concern before there's a real outbreak and then a real concern about reentry services?
Yeah, I think that.
Well, obviously.
Oh, go ahead.
Well, obviously, one of the things you point to is using the media to begin to have loved ones of prisoners who are in the situation speaking. I think all of our organizations probably have some capacity to elevate those voices. I wanted to go back to something I'd heard earlier too about these arguments that somehow keeping people incarcerated is a better thing for them and for the community. We're seeing the Department of Justice come into compassionate release litigation arguing just that the Bureau of Prisons is well equipped to take care of individuals, better equipped perhaps than releasing them to the community. Those arguments are specious. They should be embarrassed to make them. And we're trying to raise that visibility too, because the courts are not buying that. They are seeing that people in the Bureau of Prisons are dying now. Prisoners are dying in a number of facilities. And I think that they're not going to buy that. So I think to the extent that we can elevate all the efforts, all the work that all of our organizations are doing, and really expose some of the fault lines from the opposition, I think is super important, and definitely using the media and using the voices of the people who are affected by this system and by the vulnerability to COVID-19.
And I think the reality of COVID-19 and this pandemic is all of us are really only as healthy as our most vulnerable are healthy. And that's key, getting that message to policymakers, to advocates for people in prison, to governors, to anyone you can, to judges, is hugely important, because that's the basis of actions by our governor, by your governor. In our state, almost all of the other agencies have had directives around social distancing, except for prison. So congregate care facilities, nursing homes, all of those kinds of places can social distance and have been. And when COVID-19 gets into nursing homes, there is a huge level of death. We are afraid that that same death will happen because folks are elderly and folks are vulnerable health-wise, as we have already talked about. Many people in prison are not healthy. And so it's just, this issue is so urgent because whether we like it or not, there are people who go in and out of prison, staff, workers, all kinds of folks. They will bring this into and out of the prison. So again, we're only as healthy as our most vulnerable. And if we can get that message out, I think it can be powerful. We had a press conference where we had community folks lead that conference, people who have loved ones in prison, the family council for people in prison, other advocates, and they talked about this urgency, and it really connected with the media and really connected with the public. And then the attorneys got on and talked about the case. But I think leading with those stories, when you can talk about the 21-year-old pregnant woman who is in on a minor drug charge, who is sleeping with 3 other women in a cell, and one of them is sleeping on the floor near a toilet, we can't have those third world conditions anymore. Otherwise, we are never going to be able to end this pandemic in the United States of America. We have to get people out of prison. And if we can have that urgency and move forward with that, I think that can be incredibly helpful.
That's really powerful. There's a question coming through about whether the clemency process is a potential way of getting people out, and whether the governors have shown any willingness to use that for COVID compassionate release purposes yet.
I can speak to that really quickly. The governor of California issued an order trying to move that process forward more quickly by permitting video appearances by folks in prison. Our governor, at least as I know, has not acted on yet, but I think all governors have that clemency power to move things forward and could move those, reconvene those boards if they're not already convening, and move them forward for this purpose. So they have in other states, not in Washington, but I think we really could go on video and have these hearings and move things through very quickly.
I will say, though, from experience, individual representation is so important, but it's also a much slower route than trying to find a way that we can get our policymakers and decision makers and courts to release people, on a blanket basis, again, as happened in Kentucky just yesterday. People are interested in knowing how they.
If I can just add one thing.
Yes.
The law is in the way. The structures that have been set up to keep people in prison have worked a lot better than the second look provisions that somebody can reach back in and get them out of prison. I mean, it was very, very simple to get them in, but we, like in the federal system, the ability for a court to regain jurisdiction over a case is very strictly limited and has been since the elimination of parole. And that's, I think, across the board. And that's why we see that there's so much difficulty. I think everybody is aligned in many cases, but there's absolutely, under the law, there's no or very few ways to do this, and that's what we absolutely have to change. That's what we've learned doesn't work. We've all known this for a long time, but we need to take that recognition and push it out a lot harder now.
And on that point, sorry, go ahead.
Oh, I was just going to say, and pushing governors that they have the power in a state of emergency to act in a way that they never have before, and so they can act and they can release people, and they have the power and authority to do that.
Yeah, I think those muscles have atrophied a bit. It's good to remind them that they're there. Mary, just to follow up a little bit with what you said, do you want to speak a little bit more to what Attorney General Barr has proposed? And I don't know if maybe you have any comments on the bill that I know Representative Nadler and some others have introduced that would incentivize states that present credible plans for thinning the ranks of their incarcerated populations with federal funds. But just any comments you have about federal efforts that would speak to and address what you pointed out, which is, of course, it's much harder to unwind overpopulation of our prisons once it's there than it is to prevent it in the first place.
Right. So at the federal level, again, Attorney General Barr last week encouraged the Bureau of Prisons to include the presence of COVID-19 as a consideration when looking at back-end releases to home confinement. Now, that sounds good. Unfortunately, it's pretty limited. The ability of a warden to release somebody to home confinement is limited to the last 6 months or last 10% of their imposed term of imprisonment, whichever is less. And then on top of that, there are a number of restrictions. And then Attorney General Barr laid some more restrictions on top of that, including the use of this new risk and needs assessment program that was adopted in the First Step Act, which will not surprise anybody on this call, has, when it's used in this context, has a racially disparate impact on who will be considered for home confinement at the back end. So it is, I think, not only was it a hollow announcement, it was one that I think maybe even further restricts the ability of wardens to use this thing. Now, he was also given in the CARES Act the ability to announce or to make a proclamation that COVID-19 materially affects the functioning of the Bureau of Prisons. And in that case, he would be able to extend those limits of 6 months and 10% beyond that time frame. But he hasn't made that finding. And so those people, there's just 6 months and 10%. And there are some other authorities as well, but for back-end releases, including an elderly home detention program. But all of those back-end release programs in the federal system are really limited. They're limited to people without particular kinds of convictions. They're limited to people who are minimum security or below, and so forth. And the beauty about compassionate release is it's not limited to anybody. There are no restrictions or exclusions on who can ask for and receive a compassionate release from the court, but of course that provision is limited as well. I think anything the federal government can do, and I don't know where the Nadler bill is right now, I haven't been following it as closely as maybe you have, but anything the federal government can do to support this consensus among policymakers and stakeholders in the states to do more, obviously, is absolutely welcome. And forgive me, I don't know where it is and whether or not the Nadler bill has a chance of getting through the political process. But I do notice that President Trump the other day said something disparaging about letting certain kinds of people out of prison. So it makes me a little nervous. I'm not sure where things stand at this point.
Yeah, I don't either. The draft of the bill is included in the materials. If people want to look at that on the website. It occurs to me that one of the issues is that it's challenging to make an argument, for example, that on the basis of age, somebody should be released on compassionate release if the person's not demonstrably ill. But it seems like the COVID-19 might offer an opportunity there, just because age itself is just a risk factor for, the disease, and also for extreme or serious manifestations of the disease, which have the results of overwhelming the healthcare system. And so it may provide an opportunity for enhanced arguments on behalf of older prisoners who otherwise may have taken a back seat to people who already have demonstrable illness. So I don't know if anyone wants to comment on that. Those of you who've been doing longstanding work on compassionate release. We also have a number, Mary, yeah, please, yes.
Yeah, I can. I mean, there was already, again, in the federal system and in a number of state systems, there were already provisions for people who have reached a certain age and have served a certain portion of their sentence, or who have reached a certain age, served a portion of their sentence, and have age-related conditions that, limit their ability to function in a prison setting. So those already exist in a number of places. And I think you're right. They're given more poignancy and urgency in this moment. Somebody who has simply been in prison for a long time and has reached, 60 years old is now, it's much more urgent that we get them out, that we do what we can to get them out. So we're looking for all of those kinds of people in our federal work, of course, and trying to get them matched up with lawyers and into court. But it's not across the board in the states that age and time served or age and medical condition is necessarily a ground for compassionate release. So that if we're thinking about reforms going forward, I think it's really smart to think along those lines about, because people who are older and who have served a lot of time are among the most expensive to house and the least likely to return to prison if they're released. So I'm just thinking fiscally, it makes a whole lot of sense as well. But right now, again, in this emergency, they ought to be at the top of the list as well.
Thank you. We have a lot of people who are interested in diving in and helping, even college students, lawyers, people with a variety of different trainings and backgrounds. And so if you could tell us all how people can help, that would be great. People are very interested in seeing what they can do to assist with these efforts.
We're, as I said, trying to raise an army of lawyers and paralegals and social workers and doctors to rush to get prisoners the support that they need to get through the exhaustion process in the Bureau of Prisons and then file motions in court if they're denied. I'm happy to hear from anybody who's interested. We have a terrific partnership among the National Association of Criminal Defense Lawyers, my organization, FAM, and the Washington Lawyers Committee. Some of you may remember the ABA was involved in the Clemency Project 2014, and the model that we're using is a more streamlined model than that, but definitely some of the features of that campaign are being used. So anybody can contact me and I will get them to the right people. If they want to volunteer, we could always use an extra pair of hands. And I don't know if my contact information is available, but I can say it now, or we could put it on the website, whatever you think best, Miriam.
I think go ahead and say it, and they will. I think the ABA will probably follow up and also put it on the website.
Okay. So my email address is mprice, so it's my first initial and my last name, at FAMM.org. And we also have a COVID-19 website, a special website where we have tons of information. So that's another place. And then I'll get you to the right place if you're interested in volunteering. And thank you. Thanks for the pitch.
Margaret or Murph, any suggestions for where people might pitch in and be helpful?
Yeah, I mean, I would echo what Mary said, and you know, New York City has a fantastic public defender sector, Legal Aid Society, Bronx Defenders, Brooklyn Defenders, et cetera. And so I would highly recommend reaching out to those groups. You know, we are a very small but mighty, I like to say, government agency. But you know, if people are interested in learning more about the oversight work we do and the sort of oversight policy data work we do, I'm always up for talking to people. We can always use more hands.
Yeah, I think right now we're so overwhelmed with work that we have tried to think about how to use pro bono attorneys and other folks, and aren't able to make that happen right now. Usually we give individual medical cases or other types of individual civil rights cases to private attorneys. That process has slowed down right now as we have all hands on deck. And so we think that as this case goes forward, we will need folks to represent individuals as they are considered for release, and will need information or advice about their legal rights. The other piece is we have not our organization, but there's a Clemency project in Washington State, and there's innocence projects across the country that really could use volunteers to help right now in representing individuals. And also you can donate to these kinds of projects, compassionate release projects, legal aid organizations. If you don't have time, donate other kinds of resources. We have a law firm, as we're trying to get information out to people, who have donated their design department to get information out to people and create these kinds of documents and pamphlets. And it's hugely helpful, and to help with translation to get them in different languages. So that kind of in-kind support is also hugely helpful, in addition to taking on the legal work.
Thank you all so much. We have one final substantive question, and then I'm going to ask you all to move to your closing statements and advice for advocates. The question is, have any of you contended with victims' rights groups, pushback, and how that's played out in your work?
Yes, we have a group of victims advocates with Northwest Justice Project, who's our sister organization in Washington State, and receives the federally funded money, and also receives funds to represent victims of crime, sent a letter to the governor. They were advocating for release, which is great. If you can work with groups of survivors Many of them have criminal justice experience or have family members who have been through the system as well, is to have a response that says, yes, people should be released, and how can we do safe release and notification to survivors, in this. And you need to think about that and figure it out, and how can we work together to make that happen. And there are huge issues in Washington state and in other states with the notification system. Many people who are survivors do not get access to that system or are unable to get into it for all kinds of barriers. And there's racial disproportionality in who has access to that notification process and who doesn't. So I would say work with those organizations as you can. And if they are also advocating for release, which they are here, it's great. And advocating for that protects the rights of people who are survivors or victims as well. I think that can be done, that advocates for release and advocates for survivors can work together. And I can share that letter if it's not already in our materials. I can share that out.
That'd be great. Thank you so much. All right, so will each of you please, and I'll start with you, Margaret, give us your closing thoughts, your advice for other jurisdictions, you and Murph in particular, and hotspots. So, any advice you have on prioritizing efforts and triaging and what people should be thinking about as they try to achieve the work that you all are spearheading.
Yeah, I mean, I think that I would say I would ask people to pay attention to what is happening in jails and prisons and in your city, state, and nationally. Someone said earlier that these are people who tend to sort of get lost in the shuffle, and they're hugely vulnerable, and we as a society should be concerned. And so I would strongly advocate for people to pay attention and think about ways to advocate and get involved to reduce populations, to pay attention to how cities and states are responding to this crisis in these facilities. And I guess the only other thing that I would add is to also pay attention to juvenile facilities. We've talked a lot about adult facilities, and our jurisdiction doesn't cover juvenile facilities, but I think many of the problems remain or exist in juvenile facilities. So that is what I would add.
I absolutely agree. I think that's a splendid advice. And you remind me, Margaret, about the ABA Justice Kennedy Commission from years ago. And one of the things that Justice Kennedy said that prompted the ABA to set up this commission was that we couldn't, as lawyers, once prisoners had left the courthouse and gone to prison, that we as lawyers still have a continuing responsibility, and as a society have a continuing responsibility to take care, to understand, to watch, and to protect people. And he said it better than I'm saying it right now. But I feel like that's the challenge that we still have, right? This is the moment that we're in. And so, my advice is to follow Margaret's advice and to think about all the things that we can do as a legal community to reach back to the people that we had to leave behind. We lost those cases, we lost those sentencing arguments, but let's not lose them as well. So whatever we can do to honor that commitment by the ABA and our own professional commitment is going to be outstanding. And it's super rewarding work too. When somebody gets out and you get a good judge's order or a good, whatever, it is such an exciting moment. I can't tell you. So, well, so anyway, that's my piece.
Murph.
Our value as lawyers is justice for all, and we have to mean that in this crisis, that justice for all means everyone, that all means everybody, and that includes people in our jails and prisons. And we need to treat folks in jails and prisons as we are treating everyone else in our country. We have to address this crisis. I think the conversation over the last decade has changed. We now talk about mass incarceration. We talk about humane conditions in prisons. We talk about the racial disproportionality and the racial disparities and the horrible conditions in our prisons and jails across the country. And this is a moment where we can change the conversation again, where people who are in prison and jails are part of our community. We cannot pretend that they are not. They are part of our community. They are our friends. They are our neighbors. 1 in 3 people in this country has someone who has been involved in the criminal justice system. They are not the other. They are part of our communities. And I think if we can take our social media finger and push the button and share all of the articles, all of the information that is coming out about people in prison and why they should be released, and stand up and say, I believe that people should be released in prison. Put that on your Twitter account, put that on your social media. Take a picture with you writing a letter to your representative or your governor. We can do this, and I think we can save lives if we can act.
I can't think of a better note to end on. Thank you all so very much. I've learned a lot from speaking with you and from reading your materials online. Thank you again to the ABA for sponsoring this and the other educational events that you're sponsoring. And Malia, I'll leave the last word to you.
Thank you so much. And thank you to this incredible panel for taking time out of your very busy schedules and to an important advocacy to participate in this webinar and try to spread the word to other jurisdictions. We really appreciate it. As I said before, everyone who registered for the webinar will be receiving an email link to the recording of this webinar. Please share it widely. That link will also include the materials, which we will continue to update with anything that our panelists want to send us and anything else that we see that comes out. Thank you to all of our co-sponsors, and thank you to the section, particularly the section on civil rights and social justice, which makes all of these rapid response webinars possible. One last pitch, which is the ABA is doing yeoman's work here trying to get this information out. If you are not a member of the ABA, please consider it. They recently reduced membership dues for public interest lawyers really significantly. Please come join us and come work with SCLAID. We would love to have you. Thank you all.